Firstly, I would like to thank our virtual stage sponsor, Harfang IP. Their advertisement has been going on our stage live during the entire duration of the conference. You all can just go to the stage and check it out. So now we are going to move ahead with the specialized presentation sponsored by Harfang IP, and the topic of which is transparency in FRAND licensing. The speakers of which are Curtis Dodd, Chief Intellectual Property Officer, Harfang IP, and Chris Dubuc, Founder, President, and CEO, I guess, Harfang IP. So over to you guys.
Thank you. Thank you for the introduction. We appreciate the opportunity to participate in this forum. We also want to thank the audience for joining us. As introduced, myself and Kurt are going to be presenting for this session. Kurt and I are with our IP, and we've been working together for quite some time before that. We've both worked for Nortel and then WLAN, where we were doing the licensing of wireless technology, Wi-Fi related patents. We also worked together at Acacia and more recently at Longhorn IP, also doing licensing of wireless technologies. We've been focusing, and we are focusing now at Harfang IP on standard essential patents, SEPs, and on the fair, reasonable, and non-discriminatory, what we call FRAND licensing of these patents. That's the framework that's used that has been used in 2G, 3G, 4G, and now 5G. So our focus is more on the wireless technology, and as we go through the presentation, we'll pay particular attention to the wireless technology. And today, the topic of our session is transparency in FRAND licensing. We're going to talk about what we're hearing from different entities in the FRAND community about transparency. We're going to see how that lines up with the law, and we're going to also address at the end what should be done moving forward, for instance, for the 5G technology that's just being rolled out. So without further ado, as a starting point, Kurt, what do we even mean by transparency?
Again, I think Rosemary has mentioned something on the chat. Perhaps you can start by sharing what is FRAND licensing. So she's not familiar to that. I think Kurt is here.
All right. Sorry, I don't know what happened. Chris, you hung on me and then I got kicked out.
All right. Maybe we can address the question very quickly about what is FRAND licensing. As I was discussing, FRAND is the framework that is used to license standard essential patents that are used, particularly in the world of cellular communication, so 2G, 3G, 4G, 5G. It stands for fair, reasonable, and non-discriminatory. So the standard setting organization requests that people participating in the standard accept to license any intellectual property that is or may become essential on FRAND terms, and also if any additional intellectual property is identified, it will request the commitment that the patent owners are going to license also on FRAND terms. So Kurt, do you want to share the presentation from your side, or?
Sure.
So just to get back to where we were, Kurt, I was asking you, what does transparency even mean?
Thanks, Chris. First, I'm not aware of any general legal definition of the term transparency. For example, I took a look in Black's Law Dictionary, and it doesn't appear there. Excuse me. Nor does transparency defined by ETSI, which is the standard organization supporting the development of cellular standards. The word transparency does not show up in the the main document involved regarding intellectual property, which is the ETSI IPR policy. And although the term transparency does appear in the ETSI guide on IPRs, it's actually used in a different context, not FRAND licensing like we're discussing today.
Okay, so despite this, though, several FRAND statements made by entities in the FRAND licensing ecosystem have made reference to transparency, though, right?
Correct. But that being said, there doesn't appear to be much consensus as to what transparency means.
Okay. So how is transparency being interpreted?
Unfortunately, we do not have enough time today to go through all the individual statements that different companies have on their websites and in different position papers. For an overview of those, we'll direct the audience to a paper that you and I co-authored that appeared in IP Watchdog called Cellular Wireless Standard Essential Patents, a survey of FRAND-related statements. But to make a long story short, there's basically two main areas of disagreement. One, with respect to the use of agreements to maintain confidentiality. That could be a non-disclosure agreement or even within a license itself. And two, with respect to what information needs to be provided by the licensor and when.
So with respect to the first point there, the use of agreements to maintain confidentiality, it's not as simple as some are for and some are against it, right?
Correct. It's a little more nuanced and situation specific than that. For example, the Fair Standards Alliance, who counts amongst its members Apple and Google and Microsoft, for example, they argue against the use of agreements to maintain confidentiality, the idea being that they can share offers and agree to rates amongst their members. Yet at the same time, you see their members' negotiations being kept confidential in litigation. For example, if you look at the record for Optus versus Apple, you'll see that much has been redacted. Other statements from other companies like Motorola Solutions make an interesting observation, which is, if a license can only be shared on a confidential basis, use of a non-disclosure agreement can in fact increase transparency.
And it's also good to keep in mind that it takes two to tango when it comes to confidentiality. In other words, the confidentiality is not something that the licensor can impose unilaterally on the licensee. Now, with respect to what to provide and when, it seems that the implementer community has been a lot more vocal than the SCP owner community in terms of what is required. For instance, the Fair Standard Alliance, also referred to as the FSA, has advocated for the disclosure of not only the signed license agreements, but also offers prior to those agreements. So not only limited to litigation and arbitration, but during negotiation as well.
Correct. I think the relative silence from the licensor community is perhaps reflective of their uncertainty as to what exactly does need to be disclosed and when. But suffice to say, if you look through, again, the dockets and the records for various litigations involving SEPs, standard essential patents, one thing's clear is that the licensor community doesn't agree with the expansive views of the FSA.
Okay, so next, what does the law say about transparency? First of all, as a matter of contract law, the ETSI licensing declaration simply refers to granting licenses to essential IPR on FRAND terms and conditions, right?
Correct. So if you consider that the declaration that's made to the standards body is a contract which implementers can benefit from as a third-party beneficiary, if you look at the language of that contract, there's nothing in there about proving that the terms offered are being, the terms that are being offered are in fact FRAND. Certainly no requirement to do so in pre-litigation negotiations. If you look at the case out of Texas, HTC versus Ericsson, Judge Rodney Gilstrap found as a matter of French law that one who submits such a licensing declaration can satisfy its obligations by offering a license on FRAND terms and conditions or negotiating in good faith towards a FRAND license. But again, nothing about having to prove that you're doing so.
I also know that the use of non-disclosure agreements in licensing negotiation is explicitly recognized in the guide, the ETSI guide on intellectual property. It's saying in section 4.4, and I quote, "This general practice is not challenged."
Like many things, it appears that Etsy, and by that I mean the cellular industry at large, has left issues of transparency to be intentionally to be resolved by the national courts.
Okay, so if there's no contractual requirement to be transparent, how else could there be transparency? How else could that be legally required?
Presumably, it'd have to be a matter of antitrust laws, as we call them in the United States, or competition laws in Europe. I think China refers to them as anti-monopoly laws, but basically the same idea. Laws that are there to prevent unfair competition. If you look at one case that touches on FRAND issues from an antitrust perspective or a competition law perspective, Philips versus Asus out of the Netherlands, there the Dutch Court of Appeal found that the Huawei versus ZTE framework set forth by the Courts of Justice of the European Union and involves what needs to be done by a standard essential patent owner so as not to abuse its dominant position when seeking an injunction. There's no substantiation duty. Again, there's no obligation to prove that the offer you are making as a licensor or patent owner is FRAND, for example, by having to disclose all prior licenses. Interestingly, Philips was not even required to disclose its prior licenses in the litigation. The Dutch Court of Appeal characterizing Asus's request in the circumstances as an unauthorized fishing expedition. And again, it's worth noting that the Etsy Declaration itself is governed by European law. Now, from the U.S. perspective, law professor Mark Patterson, whose article we referred to in our article, says that based on other industries' practices, the use of confidentiality agreements is likely not a per se violation, meaning they're not anti-competitive in and of themselves. Rather, if someone was to bring an antitrust type claim, they'd have to show how competition was negatively impacted as a result of such agreements. And Professor Patterson, makes a very astute point, which is the obligation to license on FRAND terms and conditions can be met without proving you're doing so.
Based on the other commercial practices that we see day to day, it's also hard to see how transparency could be a requirement in antitrust law. For instance, when you walk into a car dealership, the car dealership is not expected to provide you with the pricing that they've offered to every other customers that they've had before you, and that doesn't appear to be an antitrust violation. So I think even in general, many businesses would have a difficult time if full pricing transparency would be required. So moving on to the next topic, is transparency a one or two-way street? So far, it seems like we have only talked about the SCP owner's obligation to be transparent, but what about the licensees? For instance, the Japanese Patent Office published a guide to licensing negotiations involving SCPs that proposes a mutual transparency obligation as part of the broader obligation to negotiate in good faith. It's saying that implementers shouldn't simply say that they don't infringe, but should explain why. And implementers shouldn't simply say that an offer is not FRAND, but explain why, for instance, using other licenses that they've entered into.
Right, and if you consider the rules of civil procedure in discovery jurisdictions like the United States and Canada as an analog, and these rules are also there to foster a measure of transparency, two things jump out at you. First of all, the transparency obligation is reciprocal. And second, providing discovery comes with a guarantee that the other party can't simply walk away as they can in a negotiation.
Yeah, and I must say, as a licensor, we would be a lot more comfortable sharing additional information if we knew that the result would be guaranteed, and would be also more willing to reconsider pricing if we had access to other licenses, comparable licenses that the licensee may have entered into. So next, what's really going on here?
It's similar to vice crimes, in my opinion, like gambling. And when it comes to confidentiality, it appears that people tend to say one thing and do another. In other words, as you know, my parents often said, "Do as I say, not as I do." But again, all you need to do is look at the various cases like Unwired Planet and others, and you'll see that the industry apparently prefers to negotiate confidentially.
Right, because at the end of the day, it is to an implementer's advantage if they can pay less than their competitors, or if they can pay one licensor less than another licensor for comparable patents.
Correct, but they certainly don't want to pay more than anyone else or their competitors. So hence the Dr. Jekyll and Mr. Hyde routine. On the one hand, you know, show me everything, but on the other hand, let's keep my negotiations and agreement confidential when the time comes. So, you know, for many it appears, Chris, that transparency is just, you know, the latest and yet another excuse for holdout. And it seems to be based on this flawed assumption that the patent owner carries the burden of proof and must assume all risks of uncertainty. But again, I take you back to the HTC and Ericsson case in Texas and the Philips versus Asus case in Europe. There's no such burden of proof, at least not that we've been made aware of thus far. And you'll see this reflected in Lenovo's recent antitrust complaint against InterDigital. It claims that InterDigital, quote, tilts negotiations improperly in its favor through a massive and disproportionate imposition of transaction costs, specifically by not identifying the patents that InterDigital believes are essential. But it begs the question, you know, why isn't Lenovo responsible for conducting its own analysis if it wants FRAND licenses? In other words, why does InterDigital have to show its hand if Lenovo can simply walk away and require InterDigital to prove its case in court?
I also find it particularly worrying, this argument that the so-called over-declarations to Etsy contributes to the problem that there being a lack of transparency, and this argument being used as a justification for suggesting radical changes. For instance, the European Commission expert report suggesting that there be an independent body determining essentiality. The Etsy database was not intended to be a list of essential patents. In fact, the purpose was to avoid a patented technology being incorporated in the standard without a FRAND licensing commitment. So it's actually beneficial for the Etsy and the industry at large that they receive more declarations to license more patents on FRAND terms. Finally, what would help?
Yeah, as we discussed with respect to the Japanese Patent Office guidelines and you know the rules of civil procedure, it seems like a reciprocal disclosure obligation is a good place to start as part of the broader obligations to negotiate in good faith. You know, perhaps courts should be suspicious of FRAND claims or defenses seeking to justify holdout based on transparency issues if access to that information could have been had in arbitration, for example. But beyond that, it seems to be letting the industry and the courts and competition agencies work out the appropriate approach using the existing legal frameworks makes the most sense to me.
Right. So there is no need to make radical changes to a system that's been working well for, you know, many prior generations of cellular technologies. Let's see if there are any questions from the audience. There was one that came earlier during the presentation. Is FRAND only used for patents or other IP as well? As far as I know, FRAND is very much of a patent concept. Kurt, have you heard of FRAND being used anywhere else?
Well, it's interesting. I've set I set up an alert through Lexis Advance, and occasionally I do get FRAND articles and things popping up with respect to like the supply of commodities, like selling gas or supplying, natural gas and things like that. Also involving rents, rent control in different places. Again, it's a pretty broad concept. It's fair and reasonable, and then non-discriminatory means you have to treat everybody more or less the same. It doesn't mean identical, but certainly you can't be discriminatory towards one person, charge them 10 times as much as somebody else, for example.
All right. Any other questions from the audience?
We have one question from Vanchaj. I hope we answered or not. Is it only used for patents or other IP as well? Please feel free to take this at the end of the session. So I hope we answered that.
Yes.
Yeah, no, that was the question I just answered, that you do see this popping up in other places beyond patents, but certainly in our world of telecommunications, this is the main place it appears.
So any more questions, audience? It was an interesting presentation, I would say. And any questions that are coming up from the attendees, they can write down on the chat box. They can also come online directly and join face-to-face with the speakers to ask them directly. And in the meanwhile, over to you, Ankit. The smiles.
So by the time the audience, if they have any questions, just type it down in the chat box or come up live.
So Curtis, if you would like to conclude this session in just 1 minute, so it would be great.
Sure. Nobody told us we were signing up to be models. That's not what we specialize in.
Well, again, we would like to thank you for the opportunity to be speaking at the conference, and thank the audience for joining us today. And if you have any more questions about FRAND, you can consult our website. There's also a lot of websites out there that specialize in FRAND issues. It's a fascinating world.
Absolutely. And the interesting thing is that we would also be promoting their presentation on our website for the next few months. So it'll be great that if you can have a look, and as we have so many followers, following for the IPR Gorilla, so they can look forward to have, and reach out to Harfang IP.
Thank
So
you.
Rosemary says, thank you for the interesting presentation.
Thank you for the opportunity. Appreciate it.
All righty then.
Thank you.
Thank you, everyone.